Assalamualaikum and a very good day to everybody. We are going to complete the final chapters. The final topics for the engineering and society. So in this topic, we are going to talk about the contract law, and based on the slides that were given, most of the terms are normally used in the by the lawyers. I mean that the wordings are very practically for the law, and you need sometimes to understand by reread those lines one by one. Okay, anyway, this chapter will be done in series 1 to 3 because we have a few topics need to be discussed, and you have to complete all of them before you can complete the assessment for the quiz. All right, so let's start for the chapter here for the first one. So you're going to learn about the contract. So very simple. The contract is about the thing that you are doing somebody. You are going to what do you call that? Something that you promise to somebody. Something that it can be things that you promise to somebody. It can be something that like for example the contract when you want to go for the study of overseas, right? So the government will give you the scholars and all the offers on the that will be covered by the contract. Okay, in this chapter we are going to learn about the definitions, the concept, the types of contracts, and the elements of it. And this is the whole chapter for the contract itself, for the 3 slides, the terms and conditions, the discharge of contract, and remedy. So we're going to touch about this one first. So what is contract? So contract law is actually the foundation of all commercial activities. So this is very clear that the contract law will be the foundations of all commercial activities. Okay, it can be by writing, it can be by word of mouth, or by conduct, or any combinations of it. So that will be the contract law. Okay, so the word contract in a legal sense refers to an agreement. So this is a part of it. Agreement between 2 or more parties that is legally binding between them. So when you have agreement between 2 or more than 1 parties, it can have a contract for that particular agreement. Okay, so the contract defined as the agreement enforceably by law. So means that if you have the contract there, if something wrong with the contract, it can be enforceable by the law. So you can talk to the lawyers or the experts on the law whether how you want to deal with the contract. Okay, because the contract is something that is binding for you guys to follow. Okay, so a contract is an agreement between 2 or more parties which is enforceable by law. Just for example, right? If you breach a contract, okay, for example that you are given a contract to go offer to you are given a scholar to continue your degree in at overseas, right? So you have this scholar, and then you have to sign the contract, and possibly there's a problem, right? So you may breach your contract. So once you breach, right, this is going to be the impact based on what you have signed in your contract, because this is the offer that you have. Okay, so that's the legal definition. So this is all about legal. So when one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other, such or abstinence, he is said to make a proposal. So this is about you are going to have a proposal, something that you are willing to do. You want to give somebody, you want to ask him to do. So this is there's no force on you guys, right, to do that one. So you're going to make a proposal first. This is the proposal. So then all agreements are contracts if they are made by the free consent of the party competent to contract, Competent to contract means the person is okay to do. I mean, he's willing to do, and is there's no issue for him to complete the contract for a lawful considerations with a lawful object and not hereby expressly declared to be void. So it means that if you have the person that being agreed to the contract, right, with there's no issues on based on this wording, so it means that the agreement and the contract is already there. So you have the proposal and you have the contracts on the agreements. Okay, then this is a concept. Okay, general principle for the contract, there must be a freedom for you to enter any contract. So there will be no pressure and you have to decide. You can freely decide for the terms and the contract. Okay, for the terms of the contract, this is the guidelines. You have to do this one. This is general principle. The second one is certainty of the offer, means that the offer must be a firm offer. It must be something that he's offering you. So there must be a definite intention to adhere to offer. So there will be a definite intention. So you have to complete this for the offers. So this is certainty, and that it will be, the first one is the freedom. Okay. Okay, there are three types of them. Okay, the first one, there will be unilateral. Unilateral means that only to one person only. Direct, it's one-sided. Okay, this is for one-sided. For the collateral is contract where parties one contract enter or promise to enter to another contract. Means it's just a collateral. Contract where parties to one contract to enter into another contract. So this is about collateral. Okay, so the last one is bilateral, means that this is the common type, basically. This is actually not really a fair contract because this is unilateral, right? So this is more on the common type where you have two parties agreed for the offer and proposal. So this is the normal we have for the contracts that we have for this bilateral. Okay, elements of the contract. So these are the elements, because this is the contract, this is the types of contracts. So now we are coming to the elements of contract. So how many elements of the contract is this one? So you have the first one, you must have this offer. Of course, you offer somebody first, and then the second one, the second party would be accepting the offer, will accept the offer. And then the third process is it may need to consider. There will be considerations on the offer for the contract. And then the fourth one is the intention to create legal relations. So this one is more about the legal, means that if anything happen, what you should do, what should you do, everything like that. This is about all the legal relations. And the fifth one, they call it capacity. Capacity is the what you call it. Capacity is just like whether you are entitled. Okay, whether you are entitled to sign the contract. Very simple, like the rules are very simple. The rules, like for example, that only 18 years and above can proceed with the contract. So this is about the capacity. So lower than 18 years old, you are not buying to the contract itself. It's not going to be a legal one. So this is just a capacity, means that, for example, that you are healthy enough, you are something, have all the monies. I mean, this is the rules and regulations about the capacity. Then you have the freedom of the contract. Okay, this is to set in the freedom. Then the last one is certainty of the contract. This is about that how long it will take. I mean, there will be an output from that. There will be a timeline for the contract to be completed and so on. Okay, so there are 7 of them. So you you must know that all these are elements of the contract. So let's look at the first one. The first one is the offer. Okay, what is the offer? The offer is the agreement between two or more parties. Okay, that is the offer. Okay, an offer, this is an agreement. An agreement between two or more parties is constituted by a proposal. So this is about the proposal. The second one is an offer or proposal is necessary is for the formations of an agreement. So this is agreement, this is offer. Okay, so you must have the offer first, then you can go out for the agreement. Of course, this is like you want to buy something, you go to the market, you want to buy something, right? So you're going to make an offer first, and then if the seller is ready to sell it to you, then you will have the agreement. This is kind of daily life situations. When you want to go to shopping, to Shopee, also Lazada, this all this agreement. Okay, so this is about the section. This is about all the law words. When a person signifies to another his willingness to do or abstain from doing anything with a view to obtaining the assent of that other to the act of abstinence, he is said to make a proposal. This is just a wordings, but this is about the proposal like this, just like that. Okay, example, Ali want to sell his car. He makes an offer to Rahim his car for 25,000. If Rahim says yes, the offer is set to be accepted. So you have this offer here. He said yes, the offer is accepted. Okay, when the offer has been made, it becomes promises. A person who made an offer is now referred to promisor, and the party who is accepting the proposal is referred to promisee. Okay, so in these slides, right, I mean there will be lots of cases being used as the example for the offer being made. Offer is not going to be made, because these are the cases being brought to the court to be decided, and these are the examples that how you can see that these cases have been completed, whether there is an offer or not. Okay, so let's say for example, if you want to go details on the offer cases, right, you can just go to the YouTube and type all this particular title, and you can learn from better in more by details on the cartoon. For example, here, right, this is a case. Okay, this is a case where a person want to sell this is actually a hall by using telegraph. This is very old time, right? This is 1893. So the person said there will be the answer. A wants to buy something from B by saying that he wants to buy the hall here. This is a hall. Then answer for the lowest cash price by telegraph. Okay, B replied. Okay, B replied. This is the reply. The lowest price for bumper hall pen is 900. Okay, this is the reply. This is the questions. A send telegraph. Okay, then A send telegraph. Response to this one: we agree to buy bumper at £900 as requested by you. A claim that this telegram exchange was a valid offer and acceptance. So this guy A think that he can buy that hall at £900, but based on this conversation, okay, there is no agreement to sell it. This is just to answer what is the price for the bumper hall. So this issue caused a problem where A sued B, saying that he don't want to sell it, but finally the case said, based on the case, the Privy Council of the United Kingdom decided that the statement of the fact which has been made only to provide information, this is only to provide information, should not be construed as an offer. So there is no offer being made over here. Okay, you can just try to Google it at YouTube, this case, and it's clear that based on this statement there is no offer. This is only to answer answer the questions from A, which is the price of the hall pen. So this is based whether the offer is there or not. Okay, types of offer. We have the specific offer. The offer only can be accepted by a person who's been offered. This is by for example, that you want to accept something. This is specifically for you. And the second one is based on general offer. Offer is general to be made for the public. So this is the cases that related to it. Whether the offer is okay, whether the offer is valid or not. So we can look at the example here for the case Bolton versus Jones, and the general offer is paid to the public. Khalil versus Khalil Carbolic versus Smokeball Company. Okay, this is the first one. This is about the case just now. I mean, this is a case Bolton versus Jones. This is not here. Okay, yeah, this is Bolton versus Jones. Okay, this is the case related to the company which has been transferred. What you call that? The defendant have a transaction with the dealer. So this is broker house. Okay, it was an order to buy goods to broker house. Okay, defendant is a dealer. Okay, has a transaction with a dealer named broker house. It was an order to buy goods to broker house. But on the day that the order is sent, broker house has already sold his company to the plaintiff. So this guy sue this guy. Plaintiff then sent the order good without notifying the defendant have transferred the ownership of the company, but defendant refused to buy. So what happened on that day that the goods is given to defendants, but defendant find out the broker has already been sold to another company, which is this plaintiff, and he reluctant to pay the money to the plaintiff. So plaintiff sue this guy, but at the end plaintiff cannot get their defendant is not guilty because based according to the file, the defendant do not make a deal with the broker house which is being sold to the plaintiff. The defendant only deal with the original broker house. So at that particular time, when the company had been sold to another company, so the offer has void. I mean, there's no the court decided that the plaintiff is not entitled to receive an offer because this is not directed to him. Okay, court decided that the plaintiff is not entitled to receive an offer that is not directed to him. So defendant is actually not dealing with the plaintiff. Defendant did do the deal with the broker house, but on the day that the broker has been sold to the plaintiff, defendant do not know about this. So the defendant not going to pay because this is not going to be a direct deal with the plaintiff. Okay, so that's the court cases for the Bolton versus Jones. That's very specific. So this the other one is based on the by large. This is not specific just now. This is general offer. So in this case, we have Carlyle versus Carbolic, right? This is the issues on the advertisement from Carbolic Smoke Ball, which is saying that if they use their smoke ball, right, there will be no if you're still sick but still using the smoke ball, then they're going to pay you some money. So what happened was this defendants, right, take this advertise. I mean, this is actually the offer for the public, right? So she's using this Carbolic smoke ball, but eventually she still succumb to influenza. Okay, so she wants to get the money from the company, but the company don't want to pay for it, so they are going to the court, and finally the court of appeal held that the plaintiff have accepted the offer of the company. This is just an advertisement, but she took the offer, and finally she was entitled to the money. Okay, you also can go Google this particular case to get the details on that. Okay, so for the elements of offer, so the first one, this one is about the elements of the contract. So then you have the elements of the offer. Okay, what's the elements of the offer? So you have the certainty of the offer. The offer must be firm, and there must be a definite intention to adhere to the offer. Of course, if you want to do some offer, it must be can be completely done. I mean, there must be something that can close the offer at the end. Okay, if you are doing an offer which is cannot be a definite intention to adhere, so what is going to do when you are actually in the first page doing the offer, because it's not going to be completed, right? That's the certainty. And then you have the communication to the offer, complete when it comes to the knowledge of the person to whom is made by virtue section. So this is a case. I think you can try to look at this case and what happened to the communication. So it must complete. So this offer, you have the certainty, you must communicate to it. If there's no communications for the offer, it's going to be a problem. So this case never communicate, so there will be a problem. Okay, so then you can do the terminations of the offer. So of course, when there's the offer, you can terminate it. How? By how? First one, by accept of it. Of course, when you have the offer, you accept it, then the offer is being terminated by acceptance. Then you can go for the agreement. Okay, right. Then the second one, by rejection. A counter offer is a rejection. So it means that if the guy want to sell a car at 100, but you counter offer at 95, means the first offer is not valid anymore, because you had the counter offer for the 95 ringgit. Okay, a request for information is not a rejection. So this is a request, just information, not a counter offer. Okay, just you want to know something, that is not a rejection. So the third one, by revocation. You can revoke your offer at any time before acceptance. You can revoke on it. And the next one, it by lapse. This is just like expire. The next one, by death. Okay, this is a simple. If the person who made the offer is dead, of course there's no more offer anymore. So after termination, the offer is no longer a valid offer and cannot be accepted. So once all this offer being terminated, of course there's no longer valid offer. Okay, this is about the invitation to the trade. So an offer should be contrasted with an option. So there will be something that you want to treat the invitation. I mean, invitation to the trade. So an offer should be contrasted with an option and an advertisement. So this is the process of it. An option is merely an undertaking to keep the offer open for a certain period of time. So this is just something that certain period. After that, there will be no more. So the advertisement is an attempt to induce offer. So this is the invitation to the trade. So how you want to invite the somebody to take the offers. Okay, and this is just how you want to do it. You can go for the advertisement. You can try to do the booking form, display of the goods, or the tender. This is invitation to the trade. So once you have the offer, you want to invite it, right? So this is about you have to let the process of to complete the offer. So an offer should be contrasted with the options, merely undertaken to keep, and then the advertisement is an attempt to induce the offer. So this is the process, the invitation to the trust, to the trades. So you have the advertisement, you have the booking form, display of the goods, and the tenders. So in this first series, quite very fast on the about the law. So we are going to complete this one first, up to this one and the offer. All right. For the second series, we're going to learn about more on the elements of the contracts here. All right. Thank you very much for the first one.